At Nedbank Private Wealth, we understand that real life, lived by real people, is seldom perfect. Sally is a successful businesswoman and divorced mother of 3 young children. She has traveled the world, and it was on one of her trips to America that she was presented with the opportunity to buy shares in a young startup tech company. So Sally decided to buy the shares as the business model ticked all the boxes. And if it worked, the returns would be good. And work it did. It was only 3 short years later that Sally was able to sell her shares to a foreign buyer and make a rather large sum of money. She was, however, concerned about various risk factors in South Africa and decided to keep the proceeds abroad and diversify this wealth in a variety of international movable and immovable assets, including purchasing a flat in London, therefore achieving her goal of building international wealth. Sally only has one will dealing with her worldwide estate and bequeaths the residue of her estate to an SA testamentary trust for the benefit of her 3 young children. Sally then met up with John, her financial advisor, a few weeks later. And after chatting with Sally and understanding her goals for the future, John observed that the way her will was structured, with the bequest of the residue, which includes an international wealth to an SA testamentary trust, meant all her foreign assets would have to be liquidated and proceeds returned to South Africa. So if they didn't change it, Sally's intentions of building international wealth would be defeated. When you start investing internationally, what are some of the other complexities you need to be aware of, and how can you plan for these? Let's find out.
I think the one thing this scenario in particular highlights, though, is that for us, an estate is a living thing. It's not just about planning your estate for when you pass away. You've also got to plan it so that it's optimally structured for both during as well as after your lifetime. And that's why it was so nice seeing Sally actually approaching her financial planner or her advisor during her lifetime to have that discussion. So I think, when one is investing internationally, I think there are various things that one has to consider, obviously in addition to investment selection, etc. But purely from an estate planning or wealth structuring perspective, I think there's 3 questions that really have to be answered. The first question is, what is the ideal legal ownership option in which to house your international assets? So just as an example, if you're going to hold assets in your individual name, what are the estate consequences of doing that? The estate planning consequences. And what I mean by that is if you hold assets in your personal capacity, there is no continuity on death. There is no protection of those assets. There's no easy transfer of assets to heirs and beneficiaries, etc. Whereas if you hold assets through an international trust, as an example, it generally ticks a lot of the estate planning boxes. So the bottom line is you need to look at the structure, you need to understand the estate planning consequences of each of those legal ownership options, and then decide what is the best route for you. So that's the first question. The second question that one needs to answer is, where will I be taxed on my international assets? And I think the important thing there, just to bear in mind, is that as South African residents, we are taxed on a residence-based system of taxation. But it doesn't stop there, because the minute we invest in foreign jurisdictions, there could be taxes imposed in those jurisdictions as well. So it is important to understand whether in fact that is the case or not. The third question would really be, if I'm investing internationally, do I have to have a separate will drafted? And I think to answer that question, there are 3 things one needs to look at. Firstly, one needs to look at the type of asset and the value of that asset. So in this example with Sally, she owned immovable property in the UK. Now, as we know, property laws change from jurisdiction or from country to country. So the minute you're owning immovable property, the simple answer is you should have a separate will drafted in that jurisdiction to deal with it. The second kind of question we need to ask is, what are the succession laws in that particular jurisdiction? And what I mean by that is that there are certain jurisdictions that have forced heirship rules, and you need to be aware of that when you're investing in those jurisdictions. The last thing that one needs to look at is what will the estate administration process look like? Nikki mentioned and shared with us what that was like for her experience. But what will it look like if you own assets in a foreign country? What does the estate process look like there? So the bottom line is that the complexity that's linked to investing internationally, in my mind, is once again why it is so important to seek expert advice pertaining to your particular circumstances to really come up with the right way forward for you. Thanks, Gugu.